elevating the discussion while talking about the things that matter most. You're listening to Society and the State, Life, Liberty, and Your Pursuit of Happiness. Now, your hosts, Connor Boyack and Brian Hyde.
Welcome, everybody, to episode 152 to talk about when the government can take your property. And Brian, you and I have talked about property rights a number of times on the show. And this idea that, do we have property rights, or is it more theory than fact, especially when you look at, can you actually use your property for an Airbnb, right? Or can you have a lemonade stand on your driveway?
This is one of those cases, though, that really elevates that question to...
This will make your blood boil.
Do we own property or not?
Yeah, exactly. What's the point of saying we have property rights if we actually don't? So we're talking about eminent domain. Specifically, we're joined by Dana Berliner, who's going to join us in just a second to talk about this Kelo case, which I briefly want to introduce. This is a case that happened a little more than a decade ago where a woman owned this little pink house, and the government wanted to take her home from her and her neighbors, but she resisted. Suzette Kelo is her name. And the case went all the way up to the Supreme Court on this idea, this question of, can the government take your property for economic development purposes, not to build a road, not to have a public safety building that has to go there for some reason. No, they wanted to take this land and do some economic development, rezone it, redevelop it, and then give it to Pfizer, this company that was going to be paying more in taxes for that land and that property than Suzette Kelo and her friends were. And it went all the way up to the Supreme Court, and they ultimately decided on a split ruling that, yes, in fact, the government can take your property for economic development reasons just because it wants more tax revenue from someone else who will use the property. It's maddening. So Dana Berliner is with the Institute for Justice. She was one of the attorneys on this case. Dana, so was the Institute for Justice involved since the beginning with Suzette Kelo's case? And maybe talk to us a little bit about what the lower court rulings were doing. Was this just an issue where the U.S. Supreme Court ruled in favor of the city and the lower courts were being more protective of her property rights, or was she just getting ruled against and rather the city being empowered to use eminent domain in this way all the way up the court chain?
So the Institute for Justice was with Suzette, and I was from the very beginning. We represented her all the way through. And the issue here, up until this point, I've said that eminent domain was being increasingly used for private projects, and that's true. But mostly it was being used with at least the excuse that the area itself had something wrong with it, or was blighted, or was a slum. And the U.S. Supreme Court had never decided whether eminent domain could be used for pure economic development. Mm-hmm. That is, not saying there's anything wrong with the area at all, just we want to put something else there. So this was a new issue to be decided. And the courts were very split about it the whole way. In the trial court, we had a very long trial, and the trial court said, well, so there are two things that they're planning on doing with the property. In one place, they're going to put in a grass strip that will look pretty, and then part of an office building that we introduced evidence would never be built, and there was no market for. The other properties were going to be taken for something called park support, but there was not a single witness who could tell us what that meant. So the court split it down the middle and said, for the properties that are going to be taken for the office building that won't be built, they can do that. For the properties that are going to be taken for something but they have actually no idea what it is, they cannot do that. And at that point, the owners were faced with a decision about what to do. And they were all, and still are, all friends. So nobody was willing to throw anybody else under the bus. And instead, they made an offer. Tell you what, move the homes that are in the area of the supposed office building over to the other area, put us all together. We're all neighbors and friends. Take us out of the project so we know that we're not going to be subject to eminent domain in the future, and everybody can go home. And the city said, no, we'll move the homes, but we're not going to take you out of the project because we might want to condemn you again in a couple years.
Wow.
Nice.
And they said, well, yeah, so that's not going to work. At that point, we went up to the Connecticut Supreme Court, and the Connecticut Supreme Court split 4-3. We lost again, but by one vote, because 3 of them thought that it was totally unconstitutional, and 4 of them thought, well, the city meant well, and, they had a big planning process, and economic development is important, so we're going to allow it. And we then went up to the U.S. Supreme Court, and it was exactly the same. There was a split 5-4 with 2 very stinging dissents about the demise of public use.
Yeah.
But the majority said they really reduced the right to just a procedural right, that there has to be a process that the city goes through to make sure that the public is heard. And if they go through the process and make it look like they really deeply considered what was happening, then the court will say that it's for public use. And that's taking away the right, because you can have lots of hoops, but if there's no ultimate protection for your rights, it kind of doesn't matter. So there was a 5-4 split, and they lost their homes, which was very heartbreaking. They all moved out of the city of New London. Suzette's house actually was moved to a different part of New London and is now kind of a museum for property rights. Nothing was ever built there, ever, because there was no market to actually build anything. It's a giant empty lot with a bunch of weeds and trash on it.
Wow.
It's been, quite some time, almost 15 years now. They've never done anything. Doesn't look like they will do anything. Periodically, they talk about it. The latest proposal was to put in single-family homes. But I frankly doubt they'll even get around to doing that. So they used to have a thriving neighborhood, and now they have absolutely nothing. As soon as the tax breaks expired, Pfizer moved out. So all of that was it wasn't for anything at all. Not that it would have been okay to take it for a private use, but it was for truly nothing. And that's actually always a risk, because frankly, it's not like the government is a really excellent and skilled real estate developer.
That's right.
And they don't have like they can just make up the projections and courts will accept it. Whereas an actual real estate developer will want to know that a project will work before they build it.
Dana, is there any chance that that Mrs. Kelo will ever be made whole? I mean, in my mind, the right thing to do would be, okay, so this didn't pan out. We can return the property. Does that ever happen?
It was certainly proposed. It has not happened here. There are some states now, actually, that so in the wake of this decision, as I'm sure your listeners remember, there was just a tidal wave of outrage about what had happened. Virtually nobody knew that eminent domain was being used for private projects and that you could take somebody's home because somebody richer might live there and pay more in taxes. So after that, a lot of states changed their laws, and some of them put in place a provision that if your property was never used for the purpose for which it was taken, you could get it back. But most states still don't allow that. A few do.
You talked about the tidal wave, and probably a lot of our listeners are familiar, but maybe would you briefly explain that reaction? Because my recollection and understanding is a lot of states were outraged by the court's split ruling, and in response passed legislation and then obviously toothless resolutions. But what was kind of that overall response? Were you guys gratified to see states rising up, Do you think that was more superficial than substantive, or what was that response like?
Well, so 44 states changed their laws. A lot of states made changes. And I would say at least half of those were pretty substantive changes. So the ruling from the Supreme Court was that economic development, meaning more jobs and more taxes, was a sufficient reason to take property, and that under federal constitutional law is a public use. Most states explicitly said that was not true under state law. A lot of states did more than that. Some of them said you can't take property for private projects. Some of them said you can't transfer property that was taken by eminent domain to a private party for 10 years. A lot of them changed their rules for what made an area in a condition that property could then be taken for a private project. So I would say at least half of them did something pretty substantial, and maybe a third did something amazing, a third did something pretty good, and a third did not that much. But there was a lot of change. And state Supreme Courts as well, a number of them rejected the Kelo decision as a matter of state constitutional law. In fact, one of them did it like 2 weeks ago.
Oh, wow.
The Iowa Supreme Court recently said, by the way, no Kelo in Iowa. So it's still something that is getting litigated around the country, that legislatures are still concerned about. And it's changed for the better in much of the United States, but not all of it. And that, of course, is the problem when there's no federal protection. You can have great protection in one state, mediocre in another, and no protection in a third. And that's what we've got right now.
You were right to point out that, there was a lot of opposition to what was happening here, and that what happened to Kelo would be wrong, even had they moved forward and built it. It's kind of a weird question, but do you think that getting people to understand and pay attention to eminent domain and getting them riled up would be better under a circumstance in which, Pfizer or whoever came in and built everything, and you had kind of an enemy to point to and kind of a face to the issue? Or is it superior to have barren land with weeds and trash like you do now to show the abject failure of this central planning? If you kind of had to pick one result, which do you think would be more demonstrative and illustrative of the problem?
Oh, my. I don't know, actually. I mean, they both are in different ways. I would say a lot of the private projects fail to live up to their promises. That's probably more often the case than that they actually do what they say they're going to. There are a lot of either, as I said, completely failed projects or projects that happen but aren't at all what people claimed they would be. It occasionally happens that they actually build what they say they're going to build, and it does that. But I really think both of them illustrate the problem, because either you see it was just so that a richer private business could own it, or a richer private person, or you see that it was a complete flop and it was done for nothing, and they're both bad. Really, eminent domain is supposed to be, under the Constitution, very, very limited. It's only supposed to be for a public use, meaning used by the public or owned by the public. And it's gotten so far out of those constitutional bounds.
Final question for you, Dana. In working on eminent domain and a number of other property rights type issues, I usually take occasion to ask attorneys involved in the issue their perspective on this simple question. Do property rights exist? Because we talk about it in theory, we all say how important it is, but when you see stories like Suzette's, and as you point out, many states still have very poor laws and so forth. From your perspective, do property rights actually exist? Are they more in theory than in practice? Or what's kind of your perspective on that broad question?
Well, they certainly exist because I think the right exists even if the government doesn't honor it. People have the right to live in peace on their own property and to use it in ways that don't harm other people. So I always think the right is there. And it's very speckled, if you know what I mean. Like, sometimes it's honored, sometimes it's not. It depends so much on the particular jurisdiction you're in, the particular issue you're dealing with. Overall, there are some property rights left. Owning something is not meaningless, but it should mean more than it does right now in the United States.
Certainly, there's a lot of work to be done. We've linked to the Little Pink House movie on societyandthestate.com/152, in addition to some of the resources. For those who want to learn more, reach out to your local state legislators, get involved. There's a lot of work to be done, and Institute for Justice is a fantastic organization to learn more about the issue, team up with where possible. Dana Berliner, certainly a storied background in representing Suzette Kelo and working on this issue. Institute for Justice. Dana, thank you very much for joining us.
Thank you.
Thanks for listening to Society and the State. For show notes, archives, and more great content, visit societyandthestate.com.